donc sa séance de lecture des décisions. Il s'agit des arrêts Ambrose Cheusi contre République unie de Tanzanie, l'affaire numéro 004-2015. Cette affaire sera donc, cet arrêt sera lu par le vice-président, l'honorable juge Kioko. Monsieur le vice-président, vous avez la parole.
This is the judgment of the court in application 004-2015. Ambrose Cheusi versus the United Republic of Tanzania. The court composed of Sylvain, President, Kioko, Vice President, Rafa Achour, Angelo Matusse, Marie-Thérèse Mukamuliza, Suzanne Mengue, Tujilane, Chizumila, Shafika Ben Saula, Blaise Tchikaya, Stella Ntyam, judges, and Robert Eno, registrar. 22 of the protocol to the African Charter on Human and People's Rights, and Rule 8 of the Rules of Court, Justice Imani Aboud, a national of Tanzania, did not hear this application. The parties. Mr. Ambrose Cheusi, whom we refer to as the applicant, a national of Tanzania, is currently serving a 30 years prison sentence at Ukonga prison following his conviction for the offense of armed robbery. In addition, the applicant was convicted of charges of conspiracy to commit a felony and of robbery and sentenced to 7 years and 15 years imprisonment, respectively. The application is filed against the United Republic of Tanzania, which became a party to the African Charter on 21 October 1986, and to the protocol on 10 February 2006. It also filed on 29 March 2010 the declaration and Article 34.6 of the protocol, through which it accepted the jurisdiction of the court to receive applications from individuals and non-governmental organizations. On 21 November 2019, the respondent state deposited with the chairperson of the African Union Commission an instrument withdrawing its declaration. Facts of the matter. It emerges from the application that on 6 June 2003, the applicant was arrested for having committed armed robbery of a pickup vehicle at a place known as Sinza Madukani in Dar es Salaam. He was prosecuted for the offense in criminal case number 95 of 2003 before the Kibaha District Magistrates Court. Following his appearance in criminal case number 95 of 2003, the applicant was released on bail on 7 November 2003. While he was out on bail in this case, on 3 September 2004, he was again arrested and charged in a second case. That is case number 194 of 2004 before the same court for conspiracy to commit a felony and for the offense of robbery. It was alleged that he had stolen a saloon car at Korogwe area in Kibaha district. In the first case, criminal case number 95 of 2003, he was convicted of armed robbery and sentenced to 30 years imprisonment on 22nd September 2005. The applicant appealed against his conviction and sentence before the High Court of Tanzania, Dar es Salaam on 28 April 2006 by criminal appeal number 45 of 2006. The appeal was dismissed on 21 November 2006. On 27 November 2006, he filed criminal appeal number 141 of 2007 before the Court of Appeal of Tanzania at Dar es Salaam against the decision of the High Court in criminal appeal number 45 of 2006. The Court of Appeal dismissed this appeal on 29 May 2009. In the second case, criminal case number 194 of 2004, the applicant was on 3 October 2005 convicted of the count of conspiracy to commit a felony and for the offense of robbery and sentenced to 7 years and 15 years imprisonment, respectively. On 27 October 2006, the applicant filed criminal appeal number 58 of 2006 against the sentence before the High Court of Tanzania at Dar es Salaam. On 28 March 2017, the court quashed the applicant's conviction and set aside part of the unserved sentence on the grounds that the records of his case file were lost and that the applicant had served a substantial part of his sentence. The High Court also ordered the applicant to be set free forthwith unless lawfully held for another matter. However, the applicant remained in prison serving his 30-year sentence for the conviction of armed robbery in the first case. Prayers of the parties. The applicant prays the court to intervene to remedy the violation of his fundamental rights, grant him free legal assistance under Rule 31 of the rules and 10.2 of the protocol. 3, issue an order on the undue delay in disposing of his appeal number 58 of 2006 at the High Court of Tanzania. 4, re-establish justice, quash his conviction and sentence, and order his release. 5, grant him reparation pursuant to Article 27.1 of the protocol and Rule 34.5 of the rules in order to remedy the said violations. 6, grant such other orders or reliefs as it may deem fit. In his reply, the applicant also praised the court to declare that his rights to equality before the law and equal protection of the law protected under Article 3 of the Charter have been violated by the respondent state. Declare that his right not to be subjected to cruel, inhuman, and degrading treatment or punishment protected by Article 5 of the Charter has been violated by the respondent state. Declare that his right to a fair trial protected by Article 7 of the Charter has been violated by the respondent state. 4, quash his conviction and sentence and order his release from custody given his excessive period of imprisonment by the respondent state. 5, award him the amount of United States dollars 20,000 as a direct victim of the moral prejudices suffered. 6, award him the amount of United States dollars 5,000 being compensation for the moral prejudice suffered by each of the indirect victims. 7, award him the amount of United States dollars 2,000 being the legal fees incurred during the domestic proceedings. 8, award him the amount of United States dollars 20,000 being the legal fees in the present application. 9, award him the amount of United States dollars 15,000 being reparation for the pecuniary prejudices suffered by the indirect victims. 10, award him the amount of United States dollars 1,600 for other miscellaneous expenses incurred. 11, apply the principle of proportionality in assessing the compensation to be granted to him. 12, order the respondent state to guarantee the non-repetition of the aforesaid violations and accordingly report to the court every 6 months until the full implementation of the orders. 13, order the respondent state to publish the court's judgment in the government gazette within 1 month of delivery thereof as a measure of satisfaction. 18, the respondent state for its part prays the court to declare that the application has not invoked the court's jurisdiction and therefore should be dismissed. Declare that the application has not met the admissibility conditions stipulated under Rules 40, Sub-Rule 5 and 6 of the rules, and should consequently be declared inadmissible and duly dismissed. 3, find that it has not violated Article 3, Article 7(1)(c) and D, and 7(2) of the Charter, and the application should therefore be dismissed. Rule that the applicant's prayer for release should be denied on the ground that it is contemptuous of the judgment of the Court of Appeal. 5, dismiss with cause the applicant's claim for reparations in its entirety. 6, issue such other order as it may deem appropriate and fair. The court also considered its jurisdiction to deal with this matter, and on material jurisdiction, concluded that it has material jurisdiction. On personal jurisdiction, the court notes with respect to personal jurisdiction that, as earlier stated in its judgment, the respondent state is a party to the protocol, and on 29 March 2010, filed the declaration prescribed under Article 34(6) of the protocol, through which it accepted the jurisdiction of the court to receive applications from individuals and non-governmental organizations with observer status before the African Commission on Human and People's Rights. The court also notes that on 21 November 2019, the respondent state deposited with the chairperson of the African Union Commission an instrument withdrawing its declaration. With respect to the effects of the withdrawal, the court recalls that the withdrawal of a declaration deposited pursuant to Article 34(6) of the protocol does not have any retroactive effect. Furthermore, the withdrawal has no bearing on matters pending prior to the filing of the withdrawal, as is the case with the present application. In regard to the date of entry into force of the withdrawal, the court reaffirms its ruling in the above cited Ingabire case that such a withdrawal takes effect 12 months after the filing of the instrument of withdrawal. Similarly, based on its decision in the Umuhoza Ingabire case cited above, the court holds that the withdrawal of the declaration by the United Republic of Tanzania will take effect on 22nd November 2020. In light of the foregoing, the court finds that it has personal jurisdiction to examine the present application. The court also found that it has jurisdiction with respect to other aspects of jurisdiction. The operative part of the judgment. For these reasons, the court unanimously on jurisdiction dismisses the objections to material jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objections to the admissibility of the application, declares that the application is admissible. On the merits, holds that the respondent state has not violated the applicant's right to equality before the law and the right to equal protection of the law, and Article 3(1) and 1 and 2 of the Charter. Holds that the respondent state has not violated the applicant's right not to be subjected to cruel, inhuman, and degrading treatment under Article 5 of the Charter. Holds that the respondent state has not violated the applicant's right to a fair trial under Article 7(1) of the Charter in terms of the alleged irregularities in the visual identification and denial of the opportunity to challenge the prosecution's evidence and the defense of alibi. Holds that the respondent state has violated the applicant's right to a fair trial, having failed to provide him with free legal assistance in criminal case number 95/2003, contrary to Article 7(1)(c) of the Charter. Holds that the respondent state has violated the applicant's right to be tried within a reasonable time as regards criminal appeal number 58 of 2006, examined by the High Court of Tanzania, Dar es Salaam, contrary to Article 7(1)(d) of the Charter. On reparations, pecuniary reparations. does not grant the applicant's prayer for damages arising from material loss of income, loss of life plan, financial losses incurred by himself and his wife, and for legal costs incurred in the proceedings before the domestic courts. 7, does not grant the applicant's prayer for damages for moral prejudice suffered by his wife, mother, sisters, and brothers. 8, grants the applicant's prayer for reparation for the prejudice suffered as a result of the violations found and awards him the sum of Tanzanian shillings 5,725,000. 9, orders the respondent state to pay the above sum tax-free as a fair compensation within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the accrued amount is fully paid. Non-pecuniary reparations. 10, dismisses the applicant's prayer for his conviction to be quashed. 11, dismisses the applicant's prayer for the court to order his release from prison. 12, dismisses the applicant's prayer for an order regarding non-repetition of the violations. 13, orders the respondent state to publish as a measure of satisfaction the present judgment within 3 months of its notification on the official websites of the judiciary and the Ministry of Constitutional and Legal Affairs, and ensure that the judgment remains accessible for at least 1 year after the date of such publication. 14, orders the respondent state to submit to it within 6 months of the date of notification of this judgment a report on the status of implementation of the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, does not grant the applicant's prayer in respect of legal costs and other expenses incurred in the proceedings before this court. 14, decides that each party shall bear its own costs. The judges are the same ones I read at the beginning, and in accordance with Article 28.7 of the protocol and Rules 60, Sub-Rule 5 of the rules, the separate opinion of Justice Shafika Ben Saula is appended to this judgment. Done at Arusha this 26th day of June 2020 in English and French, the English text being authoritative. Thank you. That's the end of the judgment.